This is Michael Popok, Legal AF. I can't think of a better hot take way to kick off 2024 than to talk about the 4 different trials that are all criminal against Donald Trump and the likelihood of each one of them going to trial before the November election in 2024. I'm going to talk about 4 different jurisdictions. I'm going to talk about 2 federal and 2 state cases. The only thing they have in common is that on the opposite side of the V is Donald J. Trump's name. And when you total them all up, you have 91 felony counts against Donald Trump and a jury, not a judge, who's going to be the final arbiter, who's going to render a verdict one way or the other against Donald Trump. Let me talk about each one of them in the order of when they are scheduled to go to trial, and then I'll handicap for you how I think those are going to go with the various appeals that are also pending, primarily on the federal side of the equation. The first trial I'll talk about is the March 2024 trial. 4-count conspiracy case with one defendant. His name is Donald Trump, brought by the special counsel, Jack Smith, and the case is being presided over by federal judge Tanya Chutkan. That D.C. case is scheduled to go to trial in March. It is currently stayed, meaning there's a pin in it. It's on ice until the D.C. Court of Appeals, following a January 9th oral argument, and then the U.S. Supreme Court likely, I'll talk about that in more detail, make an ultimate decision about whether Donald Trump can use some sort of presidential or office holder immunity to dismiss his indictment even without the benefit of a trial. Pre-trial dismissal of an indictment because of some nebulous concept in the Constitution of presidential immunity, which has never been stretched this far by any other former office holder, to try to claim that while he's been indicted, all of those indictments and criminal acts can be magically disappear with the wave of an immunity wand. That's Donald Trump's argument. That's in March, but that's not the only trial in March. As a backup, I'll like to call it. There's a lot of cases on trial dockets have backups that in case one settles or somebody pleads guilty, the next case up comes out of the batter's box, comes out of the on deck circle into the batter's box. And what do we have for that? Stormy Daniels. Now we move from the District of Columbia to New York. And in New York, the case is being presided over in state court. So now we've moved from federal to state court by Juan Merchan, a very well-respected state court judge there, who tried the case 2 years ago and presided over the jury trial that convicted Donald Trump's main business organizations of 17 counts of felony tax fraud. Same judge, different jury, different issue. Issue is Stormy Daniels and the 2016 hush money affair, the cover-up of the Stormy Daniels affair, using money off the company schneid, off the company dime at Trump World, and then recording it improperly in books and records of that New York corporation. That is a crime, to misrecord or improperly record or fraudulently record business expenses when they're not, and try to hide them from taxing authorities and others. There we have 34-count felony indictment against Donald Trump related to the Stormy Daniels affair and the hush money and the business record fraud that resulted. That case is scheduled, still on the docket, for the end of March of 2024. And if the case I talked about just earlier, for some reason by the appellate court, D.C. Court of Appeals or the U.S. Supreme Court ultimately finds that Donald Trump has presidential immunity. Spoiler alert, I do not believe they're going to do that. They're not going to extend presidential immunity to allow a former president to absolve himself of criminality, of criminal conduct pre-trial at the indictment stage because he just happened to be cloaked with the superpowers of President of the United States. I don't think that's going to be the constitutional precedent or case law that will be set either by the D.C. Court of Appeals or certainly not by the U.S. Supreme Court. But if for some reason I'm wrong, and it could happen, I doubt it, but if I'm wrong for this particular analysis, that case would fall away because the Supreme Court would find that there's immunity, and therefore that would be permanently taken off the docket, and then batter up, ready to go towards the end of March for the Stormy Daniels case up in New York in state court with a jury trial there. And there's nothing to stop that case There's no appeal, the interlocutory, meaning before the final conclusion of the trial, that can be taken by Donald Trump. There's no presidential immunity. He wasn't he wasn't president. He was at best in 2016 a presidential candidate, and there is no presidential candidate immunity. So that case would go to trial. 34 felony counts. You'd pick a jury in Manhattan where the case is pending, which is primarily a blue state. And then Donald Trump would have to sit for trial. Now, some people might be thinking, well, we already saw what it looks like to have Donald Trump try to sit for trial in the civil fraud case for Judge Engoron that went so terribly awry for Donald Trump. He got gagged twice and almost had his expert stricken, and he was almost thrown out of the courtroom. What will happen then, Popok? Will he do it again in criminal court? I don't think so. Two big differences. One, in the civil fraud case that already is completed except for final oral argument towards the end of January and the judge's ruling, there was no jury to worry about. So the judge could just sort of take it on the chin when Donald Trump continued to pile on him and his principal law clerk and his staff and the judicial system and everything else that Donald Trump could throw his way. And he has broad shoulders and wears a black robe, and he took it in stride. But with a jury in the box, the way Judge Merchan will have it for the criminal trial, none of what you saw will go on. And if Donald Trump continues to act out on the courthouse steps, in the courthouse hallway, in the courtroom itself, he will find himself not only being found in contempt, but will be bound and gagged and taken away from his own trial, and he will be tried in absentia. That's the power of Judge Merchan, and he's well backed up by precedent in the state of New York. So you'll have let's put it this way, a less crazy Donald Trump facing the criminal verdict from a jury that the judge is going to protect from being abused, or the justice system being abused by Donald Trump. That's March. I haven't even gotten to May of 2024. And meaning, in all these four cases I'm going to describe right now, Donald Trump, as I said in a prior hot take, has a very thin, stretched to the limit, out-resourced, outworked, outmatched, outthought, out-prepared legal team. It consists of 4 partners and a very small handful of staff and associates. That's it. Against the United States of America, the Fulton County District Attorney, the federal government, if you will. That is a mismatch of epic proportion. It's almost biblical how mismatched that resource is. The resources are on either side of that V. So they got to be preparing for all of these things simultaneously. I'm a trial lawyer. You can't just wait around. We're in January. Trials start in March. I mean, we're down to T-minus 90 days. That's not a lot of time. I usually start 6 months out from a trial date to start preparing for that trial. Or let's say I've had 2 trials go on at the same time. The most I've ever had is 3 trials go on at the same time. And you got to be preparing at 6-month mark, 8-month mark, let alone 3-month mark. So Donald Trump's team, now we're doing New York, we're doing District of Columbia, I'm moving to Florida, has to be ready. And it's the same lawyers. It's almost impossible. But this is the world that Donald Trump has created for himself, because no reasonable, legitimate law firm will represent him with all of their resources. There are bigger firms. There are legitimate firms. I've worked at a number of them. This group I just described is not that. The law firm of Haba, Keiss, Lauro, Blanche. Nobody ever heard of them before, rarely. And I think everybody will hear about them, but for all the wrong reasons when all of this is through. But moving to Florida, to just kind of stay on my track here of the trial calendar, in May, based on the courts having set the trial, Judge Aileen Cannon, federal judge, now we're back to federal court in Florida, she's got a trial setting in May of 2024 in the Mar-a-Lago espionage obstruction of justice type case against a number of defendants, but led by Donald Trump. I mean, you got Walt Nauta, his valet butler, who helped him, hide all the documents, try to drown the videotape and erase it, that guy. Along with Carlos de Oliveira, the maintenance worker, who also improperly participated in this conspiracy related to the national defense information, classified information that was being hidden and retained improperly by Donald Trump. with a cooperating witness against them, of course, of Yacil Tavares, who is the IT worker who was enlisted into the conspiracy by a combination of the maintenance worker and the butler. I know this sounds like a game of Clue, but this is really what happened. And it's a relatively simple case once they get to trial. The problem is, here comes the handicapping part of my hot take, is you got Aileen Cannon, a very inexperienced Republican Federalist-leaning judge who seems to be going out of her way, there's no other way to explain it, to give a life preserver to Donald Trump by just the way she's managing the trial, the delay that she's taking, the foot dragging in setting key hearings. Something that should be done in weeks is taking months. Decisions that should take days are taking weeks or have been put off permanently into the future. I'll give you a perfect example of what we're talking about. The trial is in May in Mar-a-Lago, at least on paper. The core issues in the case all revolve around, right, the sun around which all of the evidence and facts and indicted claims revolve around is classified information, obviously. That's the Espionage Act. That's the National Defense Information, top secret classified documents that Donald Trump not only refused to turn over, but tried to cover his tracks and hide the fact that he was retaining them. You would normally think that in a case that's been kicking around for a year or more, the judge would have already held or have scheduled, like, I should be talking about all of this next subject in the past tense. She should have already held the Classified Information Procedures Act, CIPA, hearings that are critical to a case like this. There's some hearings that Donald Trump would attend. There's some hearings that he wouldn't attend. There's a CIPA officer or a delegate that's been appointed by the judge just to make sure that both the defendant has what they need in order to defend their case under due process, but that we don't further compromise the national defense secrets of you and me, of Americans. You would have thought, okay, well, she's probably held that hearing already. Hasn't she, Popok? She hasn't. And she's put it off so far into the future, like, we'll see each other in February or March. February or March, the trial's in May. Like, there's a mismatch here. And the only way I can explain the mismatch between the trial date and these procedural orders of the judge is sort of she's, throwing a bone to Donald Trump. So that may or may not happen in May. I would think if I'm going back in time here, the March trial, Chutkan, is going to happen in March or April. It might get moved slightly after the appellate process is done and all the courts, including the Supreme Court, find that there's no immunity that stops the indictment. So I think that case goes forward in March or April. I think the Stormy Daniels case in New York, if that happens, what I just described, falls to the wayside or falls off to the sideline to be reset at another time, potentially, but not before the election. I'm not sure there's time. Maybe the summer. Let's put a pin in it. There may be time in the summer before the election for the Stormy Daniels case. So that would slide over there, in this Jenga game of scheduling that I'm outlining. Slide it over. So hold it right there. So if I'm right, the March, April trial of Donald Trump DC election interference goes forward. Stormy Daniels case would slide over, maybe take the summer slot, depending upon the Georgia case I'm going to talk about next, or get set after the election. If Trump is president, it could be stayed until after he's president, under some case law about not interfering with the president of the United States, unfortunately, even if it's a criminal matter that dated before he was president. But let's put a hold on that for a minute. So you've got the May case. If the May case doesn't happen, and I think that is more likely than the Chutkan March case not happening because of the judge. If the May case in Mar-a-Lago doesn't happen, that would open up May. Then we could have the Stormy Daniels case slide into May, although I think that's pretty close on the heels of the D.C. case, federal case. And then the next thing up on the calendar is can the Georgia criminal case against Donald Trump, 14 counts and 15 defendants, be tried in the summer before the election? And can the Stormy Daniels case be tried in the summer before the election? And that's going to be, so let me give you my handicap on it. I think it's very difficult for the Georgia case to get off the ground before November. Fani Willis has already admitted in interviews that her case is going to take her like almost 8 months, 7, 8, 9 months to try. Even if she started in August, it wouldn't go until after the election. If Donald Trump isn't elected, that's not a problem. If Donald Trump is elected, it's a problem. And the case may not continue, likely based on Supreme Court precedent, while he's president of the United States, if that terrible thing were to happen. So I'm not sure that it matters whether whether the Georgia Fulton County state court case against Donald Trump gets off the ground, because frankly, it doesn't get tried before November. The only other case that could get tried, because it's compact, the facts are not hard to prove, you only have a handful of witnesses. Alan Weisselberg, the disgraced felon of a chief financial officer for Donald Trump, would testify. Jeff McConney, who's the disgraced, now retired controller, another money bag man for Donald Trump, would testify. Michael Cohen, my podcast colleague, who used to be the inside fixer for Donald Trump, he would testify. Some people from the National Enquirer, like David Picard, would testify because he was involved with that bribery scheme involving them. There's a couple of other in-house people for Donald Trump's organization responsible for books and records who've already testified in the civil fraud case. They would testify. So it's maybe a dozen witnesses that would testify against Donald Trump, no experts. And I think you can get the Stormy Daniels case up and off if it were slotted in either May, June, when Donald Trump has the next opening on his calendar after the DC election case, or July or August. So somewhere between May and August, if you got to pick one case that's compact enough to get up and off before the election, New York, Stormy Daniels, prosecuted by the Manhattan District Attorney and Alvin Bragg. So that's the calendar that we're going to follow really, really closely on Legal AF, because we sit at that intersection, that valuable real estate corner of law, politics, and justice. And then we bring you these curated sort of hot takes and our podcast, the Legal AF pod, every Wednesday and Saturday at 8 p.m. Eastern time, and then wherever you pick up your audio podcast platforms from. We're going to follow all of that, and then we're going to put within that framework, just to give you an outline of how we see 2024, sort of a viewer's guide, is that we're also going to be talking about the Supreme Court that's going to be very, very active in January, February, March, and April about things related to Donald Trump, immunity, charges against him, whether they're going to be thrown out or not, whether he belongs on the ballot or not. There's going to be a lot of Supreme Court activity during their day job. And then on the side, they're going to be making rulings about guns and abortion. Again, unfortunately, women's right to choose, civil rights, things that matter, voting rights, voter suppression, voting maps. So we're going to follow at the state level, the federal level, the trial level, the appellate level, and the U.S. Supreme Court level. All of that. That's a pretty heavy curriculum for the Legal AF Law School, but that's what we're going to do in 2024. I just wanted to give you sort of a primer about a 10,000-foot view of how we see the calendar as we continue to drill down in our analysis. If you like what I'm doing here, this kind of hot take, this kind of, we don't blow smoke or sunshine, we don't talk down to you, we just give you the facts with our collective, 100 years of experience between the three leaders of Legal AF. If you like that, join us on Wednesdays and Saturdays, YouTube, 8 p.m. Eastern Time. And on hot takes like this one, the three leaders of Legal AF, Karen Friedman, Nick Nifolo, Ben Meiselas, me, Michael Popok, we bring it to you here on this network. And it's an independent network, no outside investors. You are the network you were looking for. So free subscribe, use your thumbs and fingers, and help them get to 2 million. It's an amazing, crazy number sometime in early 2024. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.